away from the vehicle, ma'am.
This is government property, and I have every right to be here.
But
That's enough. Give me your ID now.
Officer Thomas Brennan had been with the Richmond, Virginia Police Department for 14 years. And in those 14 years, he'd compiled a record that should have raised immediate concerns. 22 complaints, 18 of them involving African American professionals. A black surgeon in Windsor Farms, accused of loitering outside his own medical practice. An African American attorney in the Museum District, questioned about whether her Mercedes was stolen. A black college dean in Carytown, detained for matching a description that turned out to be nothing more than black male in business attire. Each one involved an African American citizen in a predominantly white, affluent setting. Each one followed the same script. Brennan couldn't believe black people belonged in these neighborhoods, owned these cars, held these positions. Each complaint ended identically. Implicit bias training that Brennan attended but never internalized. One Tuesday afternoon in Richmond, his 14 years of seeing criminality in black skin collided with someone Brennan never expected. A federal judge with 19 years on the bench. Someone who knew the law better than he ever would, knew her rights better than he understood his authority, and knew exactly what Brennan was doing. And that collision would finally end Brennan's career, cost the city $1.8 million, and expose a department that had tolerated his pattern of racial profiling for nearly a decade and a half. An African American woman in her late 50s, the Honorable Alicia Harrington, was checking her phone in the parking lot of the James River Business Center. Judge Harrington wasn't just anyone. She'd served on the United States District Court for the Eastern District of Virginia since 2005. Before that, 12 years. As a federal prosecutor, including 5 as chief of the criminal division for the U.S. Attorney's Office. She was between hearings, taking a brief call with her law clerk about a motion hearing scheduled for the next morning. Her judicial robes were hanging in her chambers 3 blocks away. She wore a charcoal suit, pearl earrings, and sensible heels. Her government-issued vehicle, a black Chevrolet Impala with federal government plates, was parked legally in a visitor space. No crime, no violation, no loitering. Just a federal judge making a phone call in a parking lot. But Officer Thomas Brennan saw her through a lens warped by 14 years of unchecked racial bias. Couldn't process that an African American woman in this upscale business district could be a federal judge. Couldn't imagine that the black woman he was about to confront had sentenced criminals, overturned unconstitutional laws, and commanded one of the busiest courtrooms in Virginia. Before we continue, where are you watching from? If this is your first time here, please hit that subscribe button. Stories like these need to be shared, and your support helps us bring more truth to light. Richmond, Virginia, the capital of the Commonwealth, a city of about 230,000 people, steeped in history, both celebrated and shameful. The James River Business Center sat in the heart of downtown Richmond's financial district, gleaming office towers housing law firms, consulting companies, financial services. Median income in this zip code exceeded $120,000. The parking lot served a complex that housed 3 major law firms, 2 investment banks, and a corporate headquarters. The area was 78% white, the kind of place where seeing a black face raised eyebrows unless that person was clearly in service, delivering packages, cleaning offices, providing security. It was 2:45 p.m. on a Tuesday afternoon in October. Clear skies, bright sunshine, mid-70s. The lunch rush had ended. Business people returned to their offices. A few walked to afternoon meetings. Traffic hummed steadily on nearby streets. Judge Alicia Harrington had been a federal judge for 19 years. 19 years of presiding over cases that shaped constitutional law in Virginia, deciding matters of life and liberty, interpreting statutes that affected millions of Americans. She'd graduated from Howard University, magna cum laude, then Yale Law School, where she served as an articles editor on the Yale Law Journal. After graduation, she clerked for a judge on the 4th Circuit Court of Appeals before joining the U.S. Attorney's Office. Her colleagues called her brilliant. Her fellow judges called her principled. Even the defense attorneys who appeared before her called her fair. She believed in justice. She believed in the rule of law. She believed that the Constitution protects everyone equally. But she also knew from both professional experience and lived reality that being black in America meant constantly proving you belonged, that racism didn't stop at judicial robes or law degrees, that white people saw the color before the credentials. That Tuesday afternoon, Alicia had just left a luncheon with colleagues from the Fourth Circuit. Nothing unusual, nothing exciting, just what she did several times a month, networking, discussing caseload management, sharing insights on complex litigation. She'd walked to her car, placed her briefcase in the back seat, and was returning a call from her law clerk about a sentencing memorandum that needed review before tomorrow's hearing. She stood beside her vehicle, a 2022 Chevrolet Impala with clearly visible federal government license plates. The registration was in the glove box, issued by the U.S. General Services Administration. Her judicial identification was in her suit jacket pocket. She belonged there, worked 3 blocks away, had parked in this lot hundreds of times. She was doing exactly what thousands of professionals do every single day, taking a work call in a parking lot between meetings. Nothing suspicious, nothing unusual, nothing that should attract police attention, nothing that would make anyone look twice at a white person doing the exact same thing. But Officer Thomas Brennan, 14 years on the yawl, Richmond Police Department with 22 complaints documenting his pattern of targeting black citizens, saw something different. Thomas Brennan had been with Richmond PD since his early 20s, joining in 2010. He'd worked various patrol assignments over the years, but spent the last 8 years on patrol in the downtown business district and affluent neighborhoods. His supervisors kept him in these assignments despite his complaint history, because, in their words, he knows the area, he's proactive, businesses like having him around. What they meant was that Brennan stopped every black person he saw who didn't appear to be in a service role, questioned African Americans about their presence in white spaces, made white business owners feel protected from black people. 22 complaints in 14 years, 18 of them involving African American professionals or residents. The pattern was unmistakable. 2016, a black accountant walking to his office in Shako Slip. Brennan stopped him, demanding ID and proof of employment, claiming he matched a description of a suspect from an unrelated case. The accountant worked for a firm in the building he was entering and had his employee badge visible. Complaint filed. Closed with implicit bias training. 2019, an African American female attorney sitting in her parked Lexus outside a law office in the Fan District. Brennan approached, questioned her about the vehicle's ownership, ran her plates 3 times, and demanded proof of insurance, even after she showed her bar card and explained she was waiting for a client meeting. She owned the car outright and was a partner at the firm. Complaint filed. Resolved with a diversity workshop. 2021. A black professor from Virginia Commonwealth University jogging through Monroe Ward. Brennan stopped him for suspicious behavior, patted him down without consent, and detained him for 20 minutes while investigating reports of break-ins that turned out to be from a different neighborhood entirely. The professor had lived in Monroe Ward for 8 years. Complaint filed. Dismissed with written counseling. Every complaint told the same story. Brennan saw African Americans in white spaces and couldn't accept their legitimacy. Couldn't accept that they belonged. He assumed stolen vehicles, assumed trespassing, assumed criminal intent before criminal activity. He demanded proof of belonging, proof of ownership, proof of legitimate presence. Things he never demanded from white people in the same locations doing the same things. And when complaints were filed, the department responded with training certificates instead of discipline. With workshops instead of consequences. With one more chance instead of termination. Internal Affairs had a file on Brennan that should have resulted in termination years ago. 22 documented incidents. 4 settlements paid quietly. 16 credible witnesses. 7 sustained complaints. But Brennan had allies in the department, supervisors who valued his arrest, statistics and his visible presence in high-income areas, union representatives who protected him at every disciplinary hearing, and a system that prioritized officer retention over accountability to the black citizens he repeatedly profiled. That afternoon, Brennan was on patrol in the downtown business district when he noticed a black woman standing beside a car in the James River Business Center parking lot. He'd driven past, circled back, watched. A black woman, business attire, nice car, on her phone. Brennan's mind made the calculation it always made. Black person plus upscale area equals doesn't belong. Black woman plus nice car equals suspicious. Professional attire on black skin equal must verify. He didn't consider that this could be someone who worked in the building. He didn't notice the federal government plates. He didn't observe that she was clearly on a work call, calm, professional, completely non-threatening. He saw what his biases trained him to see. A black person who didn't belong. A situation that needed investigation. A potential problem. Brennan pulled his patrol car into the lot, parking directly behind Judge Harrington's vehicle, blocking it in. Do you think departments should automatically terminate officers after 3 similar complaints? Drop your answer below. Alicia heard the patrol car's engine, then footsteps approaching. Her stomach tightened. She'd seen this before, studied these cases from the bench, read the statistics, heard the testimony. She knew exactly what was happening. Here we go again. Another officer who can't imagine I belong. Ma'am, I need to ask you a few questions. Alicia turned slowly, her phone still in her hand. Officer, is there a problem? Brennan moved closer, his hand resting on his belt near his service weapon. This vehicle, is it yours? Yes, officer. Is there an issue? Can I see some identification? Proof of registration? Alicia kept her hands visible, her tone measured. Officer, I'm a federal judge. I work 3 blocks from here. I'm making a work call in a parking lot. May I ask what reasonable suspicion you have for this stop? Brennan's jaw tightened. Ma'am, I don't need to explain my reasonable suspicion. I need to see identification. Now. I understand you'd like to see identification, Alicia said calmly, her legal training taking over even as anger simmered beneath. But under the 4th Amendment, you need reasonable suspicion of criminal activity to detain me. What criminal activity do you suspect? I've had reports of suspicious persons in this area. You need to cooperate. Reports from whom? What specific activity am I suspected of? Standing beside my own car? Making a phone call? Being black in a business district? Brennan's face flushed. Ma'am, if you don't provide identification immediately, I'll have to detain you. Alicia reached slowly into her jacket pocket and removed her judicial identification, a laminated card with the seal of the United States District Court, her photograph, and her title clearly printed, The Honorable Alicia Harrington, United States District Judge, Eastern District of Virginia. She held it out. Officer, I'm Judge Alicia Harrington. I've served on the federal bench for 19 years. This is my government vehicle, registered to the United States District Court. I'm parked legally, conducting legitimate business. You have no reasonable suspicion, no probable cause, and no legal basis for this stop. Brennan barely glanced at the ID. These can be faked. I need to see vehicle registration and proof you're authorized to operate this car. These can be faked? Alicia's voice remained controlled, but the edge sharpened. Officer, you're looking at a federal judicial identification with security features you can verify. This vehicle has government plates. I've explained my legitimate presence. What more do you need? Step away from the vehicle. I need to verify your story. My story? Alicia didn't move. Officer, I'm not telling you a story. I'm a federal judge. You can verify my identity by calling the courthouse. The number is public record. But you need to understand something. You've just unlawfully detained a sitting federal judge without reasonable suspicion. You've demanded identification I had no legal obligation to provide, and you're continuing this detention despite clear evidence of my identity and authority. Brennan's hand moved closer to his weapon. Ma'am, you need to comply or I'll be forced to what? Alicia's calm broke slightly. Arrest a federal judge for standing beside her own car? Detain me for refusing an unlawful order? Officer, I teach constitutional law to new magistrates. I've presided over excessive force cases. I know exactly what you're doing, and it's called racial profiling. A white woman in her 60s, a partner at one of the law firms in the building, had been watching from a second-floor window. She recognized Judge Harrington. had appeared before her in a trademark infringement case 2 years earlier. She came down immediately. "Officer, excuse me. That's Judge Harrington. She's a federal judge. I've practiced before her. This is completely inappropriate." Brennan turned. "Ma'am, I need you to step back. This is police business." Police business? She's a federal judge checking her phone in a parking lot. What crime do you think she committed? A black man in his 40s, a paralegal from another firm, approached. "I've been watching this. Judge Harrington has done nothing wrong. She's been standing here making a phone call. That's it. This is harassment." Within minutes, 3 more witnesses had gathered: a Hispanic business owner from across the street, an Asian American attorney who'd just parked, a white man who'd been walking his dog, all of them saying the same thing. Judge Harrington had done nothing suspicious. She was clearly a professional. The officer had no basis for this stop. Brennan, realizing the situation was spiraling, called for backup. Sergeant Michelle Torres arrived within 4 minutes, a 16-year veteran who knew Brennan's complaint history and had pushed for his termination twice. She stepped out of her vehicle and immediately assessed the situation. A woman in a business suit, federal government vehicle, holding judicial identification, surrounded by witnesses all defending her. "Brennan, what's the situation?" "Suspicious person call, Sarge. I'm verifying identity and vehicle ownership." Torres took the judicial ID from Judge Harrington, examined it carefully, then pulled out her phone and called the U.S. District Court's main number. 2 minutes later, she had confirmation. Judge Alicia Harrington confirmed on the bench. Currently in active service, vehicle registration matched the federal database. "Brennan, this is a federal judge. Her credentials are legitimate. Her vehicle is registered to the court. What was your reasonable suspicion for this stop?" Brennan hesitated. "Report of a suspicious person in the area." "What specific suspicious behavior did you observe?" Subject was standing by a vehicle for an extended period. Standing by her own vehicle? In a business parking lot? During business hours? "I needed to verify." "Verify what?" "Brennan, she provided federal judicial identification. She explained her presence. You had no reasonable suspicion, no probable cause, no legal basis to continue this detention." Torres turned to Judge Harrington. "Your Honor, I apologize. This stop should never have occurred." Within 15 minutes, Captain Robert Ashford arrived, a 22-year veteran who'd been trying to discipline Brennan for 6 years and had been blocked by command staff and the union every time. He stepped out of his vehicle and saw immediately what had happened: a federal judge being detained by an officer with 22 complaints, witnesses recording on phones, his department's liability skyrocketing by the second. He listened to Torres's briefing, examined Judge Harrington's credentials, spoke with the witnesses, and reviewed the timeline. Then he turned to Brennan with an expression of absolute finality. "Badge and weapon, now." Brennan's face went pale. "Captain, I was just..." 22 complaints, Brennan. 18 of them just like this. Black professionals in business districts. And you couldn't accept they belonged. You just racially profiled a federal judge in front of witnesses and cameras. Sir, I had reasonable suspicion. You had bias. You had assumptions. You had 14 years of seeing black skin and assuming crime. Badge and weapon. You're on administrative leave effective immediately, but let's be clear. Your career is over. Brennan handed them over, his hands shaking. Captain Ashford turned to Judge Harrington. Your Honor, on behalf of the Richmond Police Department, I apologize. This was racial profiling. This was a violation of your rights. This was exactly the kind of incident we've been trying to prevent. Trying to prevent? Judge Harrington's voice was controlled, but her anger clear. Captain, Officer Brennan has 22 complaints, 18 involving African Americans. That's not trying to prevent. That's tolerating. That's enabling. You're right, Your Honor, and Officer Brennan will be terminated. If you choose to file a complaint or pursue legal action, and you should, the department will cooperate fully. This pattern needed to end years ago. Judge Harrington looked at Brennan, then at Captain Ashford, taking a moment to process what had just happened. Captain, I've served on the federal bench for 19 years. I've presided over hundreds of civil rights cases. I've studied Fourth Amendment violations, reviewed excessive force claims, ruled on qualified immunity defenses. I teach seminars on constitutional policing to federal law enforcement. She paused, her voice steady, but carrying the weight of decades of experience, both professional and personal. And your officer just detained me for standing beside my own government vehicle in a business parking lot. He demanded identification I had no legal obligation to provide. He refused to accept my federal judicial credentials. He continued the detention even after I cited the constitutional violations he was committing. She gestured toward the witnesses, several still recording. Everything is documented: the lack of reasonable suspicion, the racial profiling, the Fourth Amendment violation, all of it. So yes, Captain, I'll be filing a complaint. And yes, I'll be pursuing legal action. Not for money, but because if this happens to me, a federal judge with 19 years on the bench, someone who commands a courtroom, someone with institutional authority, imagine what happens to people who don't have my credentials, my knowledge, my platform to fight back. She looked directly at Brennan. How many young black men has Officer Brennan stopped who couldn't cite the Fourth Amendment? How many African American women did he profile who didn't have witnesses recording? How many people did he harass who had no recourse? By that evening, the story was spreading through Richmond's legal community and onto local news. Video clips from witnesses' phones went viral. Chad Judge profiled and Justice for Harrington started trending. Headlines appeared within hours. Federal judge racially profiled by Richmond officer with 22 complaints. U.S. District Judge detained for standing while black in parking lot. Richmond officer suspended after profiling federal judge. The legal community responded immediately and forcefully. The Virginia State Bar issued a statement supporting Judge Harrington, calling the incident a clear case of racial profiling against one of Virginia's most respected jurists. The Federal Judges Association condemned the incident, demanding accountability and systematic reform. The Richmond Bar Association, the Virginia Association of Criminal Defense Lawyers, and even the U.S. Attorney's Office for the Eastern District, where Judge Harrington had worked for 12 years, all issued statements supporting her and calling for Brennan's termination. The courthouse where Judge Harrington presided received hundreds of calls and emails of support, along with demands that the Richmond Police Department face consequences. Judge Harrington hired Marcus Fleming, a prominent civil rights attorney who'd won $12 million in settlements from Virginia police departments over the past decade. The lawsuit was filed 3 weeks later, naming Officer Thomas Brennan, Sergeant David Walsh, who'd supervised Brennan despite his complaint history, Captain Christopher Henley, who'd kept Brennan in downtown assignments, and the Richmond Police Department. The allegations were devastating. Racial profiling in violation of the Equal Protection Clause of the 14th Amendment. Unlawful detention without reasonable suspicion or probable cause in violation of the Fourth Amendment denial of civil rights. Under 42 U.S.C. Cifr 1983, intentional infliction of emotional distress, false imprisonment, supervisory liability for failure to train, discipline, or terminate, despite documented pattern. Municipal liability for deliberate indifference to Officer Brennan's pattern of racial profiling. Violation of Virginia's civil rights statutes. The complaint included Brennan's entire history, 22 complaints over 14 years, 18 involving African Americans in similar circumstances, affluent areas, business districts, professional settings, all documented, all investigated, all resulting in minimal discipline, all dismissed with training that never changed his behavior. The lawsuit laid out the pattern systematically, complaint after complaint, year after year, black victim after black victim, similar circumstances, similar assumptions, similar harassment, $1.8 million in damages, plus attorney fees and mandatory policy reforms. Richmond city attorneys reviewed the case. The liability was clear. Security footage from the business center showed everything. Judge Harrington making a phone call, Brennan's approach, the escalation despite her cooperation. Body camera footage captured Brennan's inability to articulate reasonable suspicion, his dismissal of federal judicial credentials, his continuation of the stop without legal basis. Multiple independent witnesses, white, black, Hispanic, Asian, all corroborated Judge Harrington's account, her credentials, her vehicle registration, her government plates, all proved her complete legitimacy. Brennan had no legal basis for the stop, no crime, no reasonable suspicion, no articulable facts, just a black woman in a business district, and he assumed she didn't belong. Internal affairs files documented the pattern: 22 complaints, 18 involving African Americans, all ignored with minimal consequences. Every element of a Power 1983 claim was present. Fourth Amendment violation, check. 14th Amendment violation, check. Municipal liability for deliberate indifference, check. Qualified immunity wouldn't apply given the clear precedent against racial profiling of citizens engaged in entirely lawful activity. The city's risk assessment was clear: go to trial and lose publicly, with a jury verdict potentially 3 times higher, or settle now and implement reforms. The city settled 11 months later. $1.8 million paid to Judge Alicia Harrington, one of the largest settlements in Richmond history for racial profiling. Officer Thomas Brennan was terminated 4 weeks after the incident. The union initially filed grievances, but withdrew after reviewing the body camera footage, witness statements, and Judge Harrington's testimony. The termination letter was comprehensive. Officer Brennan engaged in racial profiling, detaining a federal judge based solely on race without reasonable suspicion or probable cause. He violated department policy on constitutional policing and bias-free policing. He has demonstrated a pattern over 14 years of similar conduct involving 22 complaints, 18 against African American citizens, indicating this was not an isolated incident, but a persistent failure to serve all residents equally. His continued employment creates unacceptable liability for the city and violates the civil rights of citizens, particularly African American residents. Employment terminated immediately. No appeal rights due to the severity of constitutional violations. Brennan's name was entered into the National Decertification Index, preventing him from ever working in law enforcement again anywhere in the country. His 14-year law enforcement career ended permanently. No pension enhancements, no retirement in good standing, no law enforcement work anywhere. Judge Harrington testified before Richmond City Council at a packed hearing 2 months after the incident. Supporters filled the chamber, attorneys who'd practiced before her, law professors, community activists, fellow federal judges, civil rights leaders. I'm a federal judge. I've dedicated 31 years to the law, 12 as a federal prosecutor, 19 on the bench. I've lived in Richmond for 3 decades. I've sentenced criminals, protected constitutional rights, and presided over some of the most significant cases in this district. I know my rights. I know the Constitution because I interpret it every single day. I know what unlawful stops look like because I've ruled on hundreds of them. And Officer Brennan detained me for standing beside my own government vehicle in a parking lot. He treated me like a suspect. He dismissed my federal judicial credentials as potentially fake. He continued an unlawful stop even after I explained the Fourth Amendment violations he was committing. She paused, looking at each council member. 22 complaints over 14 years, 18 involving African Americans. That's not mistakes. That's not bad luck. That's a pattern. That's policy. That's the department tolerating racism. A pattern your department tolerated for 14 years. Because Officer Brennan's supervisors valued his visible presence in white neighborhoods over the constitutional rights of the black people he profiled. She paused again, letting the words settle. $1.8 million is what it cost to finally remove one officer who should have been fired after complaint 5. But money doesn't undo standing in a parking lot being treated like a criminal by an officer who couldn't imagine a black woman could be a federal judge. It doesn't erase the message that 19 years on the bench matters less than my skin color. And it doesn't prevent the next officer with 22 complaints from doing the same thing to the next victim who can't fight back. This council needs to ask itself, why did it take 22 complaints? Why did it take a federal judge? Why did it take someone with my resources and platform to finally get action? And what happened to all the victims before me who couldn't fight back? Standing ovation from supporters. Several council members visibly uncomfortable. Richmond Police Department announced policy reforms 8 months later under pressure from the lawsuit and community demands. The chief acknowledged the need for change at a press conference. The reforms included automatic supervisory review after 3 complaints with similar patterns within 36 months, mandatory termination proceedings after 4 sustained complaints involving racial profiling, real-time flagging system for officers with patterns of stops involving racial disparities, mandatory supervisor approval for any stop in business districts involving only suspicious person calls without specific criminal activity, body camera footage, review of 100% of stops involving minority citizens in predominantly white areas, anti-racism training conducted by civil rights experts and former victims of profiling, not police trainers. Command staff accountability. Supervisors who ignore patterns face discipline up to termination. Community Oversight Board with subpoena power to review complaint patterns. Quarterly public reporting of stops by officer, race, location, and outcome. Integration of National Decertification Index checks to prevent hiring officers terminated for racial profiling elsewhere. The police union initially opposed several reforms, particularly command staff accountability and the 4-complaint rule, but relented under public pressure. Why do departments wait for the 22nd complaint instead of acting on the 3rd? Why does it take a lawsuit to implement common sense accountability? Comment your thoughts. Reforms to be fully implemented within 12 months, with progress reports every quarter. This wasn't about one afternoon. This wasn't about one stop. This was about a department that tolerated Officer Thomas Brennan profiling black citizens for 14 years, despite 22 documented complaints showing a clear pattern of racial profiling. The pattern was obvious from complaint 3. A black professional questioned in a business district. An African-American resident asked for proof in their own neighborhood. It was undeniable by complaint 10. Same story, different victim. Same bias, different day. Same assumptions, different location. But Richmond PD kept Brennan on patrol, kept assigning him to affluent areas and business districts, kept ignoring the warnings, kept accepting the excuses until he finally profiled someone with the knowledge, resources, and platform to force accountability. Judge Alicia Harrington paid the price, treated like a criminal in a parking lot where she'd parked hundreds of times, detained for making a work call, humiliated, despite providing federal judicial credentials. The message delivered clearly. 19 years on the bench doesn't matter as much as your race. Thomas Brennan's career is over. Terminated. Decertified. Barred from law enforcement permanently. That's consequence. The city paid $1.8 million. That's accountability. The department implemented reforms. That's progress. But those measures came after 14 years and 22 complaints. 14 years of black victims who didn't have a federal judgeship, legal expertise, or institutional authority. 14 years of African American citizens who were profiled and had no recourse. No witnesses, no cameras, no resources, no platform, no one listening. How many others did Officer Brennan stop in those 14 years? How many young black men detained without cause? How many African American women questioned about belonging? How many professionals humiliated who couldn't fight back? How many complaints never filed because victims knew nothing would change? The real question isn't why Officer Brennan did this. The question is why the system let him keep doing it. Why do departments wait for complaint 22 instead of acting on complaint 3? Why do they recognize patterns after 18 similar incidents instead of stopping them after 5? Why do they prioritize protecting officers with documented racist patterns over protecting the black citizens those officers target? Why does it take a federal judge, someone with credentials white people respect, to finally get accountability? Why do settlements come from taxpayer money, while officers who cause them face no financial consequences? Because if we don't fix the system that kept Thomas Brennan patrolling white neighborhoods for 14 years, if we don't address the culture that valued his statistics over civil rights, if we don't hold supervisors accountable for ignoring obvious patterns, then we're just waiting for the next officer with 22 complaints. The next victim, the next African American professional who gets profiled for having the audacity to exist in the wrong neighborhood with the wrong skin color. This case represents thousands of others that never make news. Tens of thousands of Black Americans profiled every year by officers who never face consequences. Millions of stops based on race, not crime. A system where being Black is treated as reasonable suspicion. Comment if this should be federal law. Any officer with 4 similar complaints within 5 years faces automatic termination. No implicit bias training that doesn't work. No diversity workshops that change nothing. No progressive discipline that protects racism. Immediate termination. Career over. Out of law enforcement permanently. And if you believe these stories matter, if you think 14 years of complaints should result in accountability before year 15, if you believe Black professionals deserve the same presumption of belonging that white people get automatically, then hit that subscribe button. We're exposing racial profiling in law enforcement. We're demanding real accountability. We're fighting for every Black American who's been profiled without the platform to fight back. This isn't about one officer or one federal judge. It's about a system that gave Thomas Brennan 22 chances, 22 complaints, 18 Black victims, 14 years, while Black Americans don't even get the benefit of the doubt. It's about departments that protect officers with documented patterns of racial profiling and the African American citizens who pay the price for that protection with their dignity, their safety, and their constitutional rights.